another series for Ask Jade. I'm going to cover agreements, contracts, bartering agreements today. So agreements are a big part of running a business, and these typically include partnership agreements, employment contracts, purchase agreements, and a variety of other agreements that are usually very carefully drafted and reviewed before they're signed. Yet, we all know, especially as small business owners, that bartering agreements are pretty common, where you agree to exchange goods or services in exchange for someone else's goods or services rather than exchanging money. And this is very common, and usually this is not put into writing. Example, a plumber agrees to exchange his plumbing services for his dentist services, and they'll just agree to do that verbally. Nothing is put into writing. Side note real quick, the IRS always wants their piece, so if you are accepting goods and services in exchange, you do have to claim the fair market value of those goods or services that you received. Just a side note. So let's say two parties enter into a verbal or oral agreement to exchange services, and one party holds up their end of the deal while the other party refuses to make payment or deliver what they promised. Is this enforceable at all in Illinois? Yes, verbal and oral agreements are enforceable in Illinois, but much harder to prove if you don't have something in writing. So you would have to prove that there was mutual consent to the agreement, that the offer was made by one party and accepted by the other party, that the non-breaching party actually performed their obligations under the contract, which can be pretty easy to do if you actually did provide some sort of service or good. You can prove that. And that the parties acted in good faith throughout the process. So the key is really that performance, which you should usually be able to prove pretty easily, and the acceptance of that performance. And then you can try to get some legal recourse if you don't have a writing to refer to. But also another note, some agreements must be in writing or there will be absolutely no legal recourse. And some of those agreements include contracts involving selling an interest in land, contracts where performance takes longer than 1 year, contracts involving the sale of goods valued over $500, and certain promises made by executors and administrators of estates. So any type of those agreements must be in writing. Otherwise, if you have some bartering agreements that are verbal, they're very hard to prove, but you do have some possible recourse in Illinois. But at the end of the day, it is always best to put agreements in writing. It creates a permanent record of the agreement that can be used to enforce the terms of the contract if necessary. So keep that in mind when you are making agreements with other small business owners or customers and clients, and that it is always best to put your agreements in writing and have them reviewed and drafted by an attorney. But you do, or you may have possible legal recourse in Illinois with a verbal agreement.